Hello, welcome to SanskarEdutech. I am Dr. Rita Bansal, in charge principal of dtsscollege of Rita. Let us have a look at law of torts today. Let us first have a look at what is a tort. The word tort is derived from the Latin word tortum, which means twisted, which means wrong. It basically refers to a civil wrong that is other than breach of contract or breach of trust, for which the remedy is compensation in the form of damages. So basically, tort is a civil wrong for which the remedy is an action for unliquidated damages, and which is not exclusively a breach of contract or breach of trust or other merely equitable obligation. In short, we can say that if one person's wrongful act causes injury to another person's legal rights, then the wrongdoer is liable under tort law. Let us take some simple examples to understand tort in our daily life. Say, for example, a driver not stopping at a red light and he hits a pedestrian. This is tort of negligence. Say, for example, a factory constantly emitting smoke, making neighbors sick. This is public nuisance. Another example is, say, spreading false rumors about a person's character in society. Defamation. Entering someone's private land without permission. Trespass. Or intentionally hitting someone during an argument. This is called battery or assault. These are not crimes in themselves, but though some acts may overlap with crimes, but the primary object is to compensate the victim. So what is this tort? What is the nature of tort? The basic nature of tort is that it is a civil wrong. Tort deals with violation of private rights. The injured party, that is the plaintiff, can sue the wrongdoer. Who's the wrongdoer? Wrongdoer is the defendant. Say, for example, if someone drives negligently and injures another party, so the other party can sue him for damages. Another nature of tort is unliquidated damages. So unliquidated damages means the compensation is not pre-decided, but it is determined by the court based on injury suffered. Say, for example, if someone's reputation is harmed due to a defamatory statement given by someone else, then the court decides the compensation depending on the seriousness. Another nature of tort is that it is right in rem, that is against the whole world. Tort protects rights which are enforceable against all, unlike contracts which bind only the parties. Say, for example, everyone has a duty not to trespass on another's land. This is right in rem. Another nature of tort is that it is a contract. It is independent of contract. It is not a contract. A tortious liability arises without agreement between parties. Say, for example, a shopkeeper pushing a customer is a tort. That is battery, not a contract breach. Another nature of tort is that it is false-based liability. Most torts arise because of fault. What is fault? Fault is negligence, intention, or strict liability. Say, for example, if a person brings something dangerous on the land, then he is liable when it escapes, and this attracts strict liability. As far as the scope of tort law is concerned, Indian law does not have a codified law of torts, unlike BNS or Contract Act. It is mainly based on English common law and judicial precedents. But yes, of course, there is a wide scope which is covered through various acts or examples which we can take to understand the scope of tort law in India. Look at medical negligence, where doctors or hospitals are held liable for negligent treatment. In case of industrial liability, principle of absolute liability was evolved. it is even stricter than strict liability. As far as environment protection is concerned, polluting industries are made liable to compensate victims and restore environment. Look at even the scope if we look at consumer protection. So though consumer cases are decided under the Consumer Protection Act 2019, but they are based on tort principles like negligence, like deficiency in services. Another nature of tort is defamation. Politicians, celebrities, they often sue for tort of defamation, which is a civil remedy. There are various objects of law of tort in India. One is related to compensation to victim. Another is deterrence, protection of rights, justice, development of social policy. So basically, the primary aim is to place the third party in the same position as if wrong had not occurred. Say for example, award of damages to an accident victim for medical costs, loss of income, etc. It also acts as a deterrent. It prevents people from committing wrongs by making them pay damages. Say for example, heavy damages on polluting industries to discourage future negligence. So basically, tort law balances rights of individuals with duties to society. Torts safeguard rights like right to reputation, right to safety, right to property, right to environment. And courts use tort law to adapt to modern problems like cyber defamation, environmental hazards, or consumer disputes. So basically, when we look at tort in India, is a civil wrong. Mainly it is a judge-made law which is focused on compensation rather than punishment. Its nature is fault-based, civil, and it is independent of contract. Its scope is expanding to cover medical negligence, environmental protection, industrial liability, and also consumer rights. And its objects is not only to compensate victims but also to ensure deterrence, to ensure justice and protection of fundamental human rights. When we look at torts, then we find that there is a difference between tort and crime. What is tort? Tort is a civil wrong where the main object is to compensate the injured party. On the other hand, what is a crime? It's a public wrong which is prosecuted by the state to punish the offender. Say for example, if A slaps B, then as a tort, B can sue A for damages, that is, he'll receive compensation for the injury caused. But as a crime, the state prosecutes A under BNS for causing hurt. Similarly, there is also a difference between tort and breach of contract. Tort is what? It is a duty which arises from law owed to the world at large. On the other hand, contract is a duty which arises from agreement owed only to the parties who consented. Say for example, a bus owner contracts with another person to take him safely to Pune. Now, if the driver drives rashly and injures that other party or the other person, then under breach of contract, there is a breach of promise to carry him safely, and under torts, it amounts to negligence because careless driving also injures duty owed to public. Similarly, there is also a difference between tort and breach of trust. Say for example, if a trustee misuses trust property, then the beneficiary sues for breach of trust, not tort. At the end, we can say that as far as tort is concerned, tort differs from crime. It differs from contract. Under tort, anyone can sue whose right is violated. That person has a right to sue. And who may not sue? Those without legal injury. Who may be sued? Any wrongdoer. State, corporation. And who may not be sued? Like judges, legislators, sovereigns. So as far as tort is concerned, it is a civil wrong rather than a breach of contract or breach of trust, for which the remedy is compensation in the form of damages. So this was an overview on tort, and in the next session I'll be taking up the topic on damnum sine injuria and injuria sine damnum. Thank you.